everyone. My name's Elizabeth. I'm from the Legal Advice Centre. This is my colleague Jenny Graham and also Eddie Coppinger sitting on the end here. We're going to cover legal expenses insurance and specifically how the not-for-profit sector can utilise this resource in order to have effectively another source of funding. It's quite a lot of material, albeit you will have the detail of it in the brochures already, and you can also get it. You can also get it from David. So some of the more detailed slides I may skip over. But the general gist will be covered. Okay, so legal expenses insurance itself. Right, as well as providing, basically this is something that's generally provided on a standalone as well as being commonly included in general policies. The most common one is usually household policies, although it can be included in credit cards. For example, American Express has legal expenses insurance automatically added. Also some more sophisticated motor policies, annual travel insurance and managed bank accounts, many of which have legal expenses insurance added. Some of them also, for household policies, you tend to have a free or low cost edition. So typical cover will include things like personal injury, consumer, property and employment disputes. It also covers the award of the other party's costs in the event that you lose. Normally, any legal action for which the expenses are incurred must have a reasonable prospect of success. In addition to that, you're usually required to accept any reasonable offer of settlement. Right. So, with legal expenses insurance comes panel solicitors. So these panels are set up by the insurers to deal with cases on commercial terms generally agreed in advance. Right, the terms may be agreed on a no-fee basis or on a fixed cost basis or on a fixed hourly rate basis. So you ask yourself, why are we bothering to do a seminar on this if panel solicitors manage this? We will come to that in a minute. There are various LEI providers. Have you got that slide? Okay. So these are some of the insurers that will provide LEI cover. You can see the additional cost to the policy in each case, and you can see that for one or two of them it's standard. Okay, so the reason why the not-for-profit sector might be interested in LEI, and we will come to this later on, but I will sort of bring this forward a bit, is because there are opportunities for solicitors in law centres and not-for-profit organisations to undertake LEI work instead of panel solicitors. And this is really what the gist of this seminar is going to cover. So, how do you actually get the clients through the door that might have LEI insurance cover? So one of the things is that many law centres specifically and other not-for-profits will means test their clients in order to offer them a service. So you have to be really careful about this, because you may well means test your LEI clients out of the door before you even get the opportunity to establish whether they have this cover. So with a means test, a general means test, you might also want to add questions about LEI in order to see if the clients actually are covered with this means, with LEI cover. And in order to do that, what we've generally done is developed a questionnaire. So this is the questionnaire that we would use, or this is a questionnaire that you can use in order to find out if your clients have LEI cover. Okay then, next slide. To making sure you're ready. Okay then, so you've potentially got LEI clients coming through the door. What do you do now to ensure that you can actually take those cases on? Okay. Right, so surprisingly there's actually very little regulation. So just the main things really. The SRA compulsory cover professional indemnity insurance is one of the issues that you have, one of the things. Many of you will probably have this anyway. There's no industry standard cover, so for the purposes of doing LEI work, there's no specific cover that you have to take out in order to do it. So you just have to have the insurance in place as part of the terms of the appointment from insurer. So, for example, a client comes in, they've got a DAS insurance, so then you have DAS requirements. And these would be that your employer's liability insurance is 10 million, public liability insurance is 5 million, professional indemnity is 10 million. With Family Plus, which is another provider, they made no specifications whatsoever. It is sometimes possible to actually negotiate with these insurers and actually take them down, because sometimes the amounts or the cover for insurance is more set for national practices rather than regional practices. So it's sometimes possible to negotiate and say, well, why should we have to have £10 million cover? Is that necessary? And they have to think about taking that considering that. So suitably qualified staff, you obviously need a supervising solicitor. And you also would need a suitable case management system for recording and billing. Those of you that have got legal aid contracts will already have something in place for time recording, and also for establishing hourly work. Let me start again. You will have something in place for time recording, and if you're working under a certificate, also for billing as well. Okay, and I know some law centres have actually set up charging wings. And if you've got a charging wing, the presumption would be that you would, again, have a sophisticated system for recording and billing. You can just adapt that for the purposes of LEI. If you do have a charging wing, you might also want to think about the rates you charge for LEI, because you could potentially argue that you want to do it on a commercial rather than a concessionary rate. So, the LEI process applying for funding. So what you would be asking your client to do that has LEI cover is contact their insurance company. Can you go back? Or does it carry on? Yeah, carry on. Okay. So your client contacts their insurance company. They would normally be expected to do this within 180 days, sometimes less. And then the insurer will make a decision on whether or not to fund their case. Okay. Carry on. Right, so the insurer will be looking at whether or not your client has a reasonable prospect of success, which generally means 51% or more chance of winning. Prospect of success. Legal expenses policies contain clauses that specify that they will withhold or withdraw funding if the action doesn't have this prospect of success, or it's later assessed as not having a prospect of success. So the FSO interpret reasonable prospect of success as 51%, not 50%. And for a claim to be taken up, your insurer must be satisfied that you have a reasonable or better than average chance of winning your case at any time, and not just when the claim is first raised. So case examples. One case which was initially rejected by an insurer, this is one of the cases we took on, for lack of merit, went on to win at the tribunal. Client received £65,000. Other cases, all our other cases have settled. So what this effectively means is you will quite often, if you have a really good case, the insurers will still probably assess it as having less than a reasonable prospect of success. That doesn't mean to say that it cannot be challenged. To the next one.
Next one is just a case example.
Carry on. Okay. So here we are. So this is coming on to the challenge now. Right, so what do you do if the insurer refuses to fund the claim? So they often refuse to fund the claim in the first instance. I think nearly all the cases we've taken on have initially been, insurers have initially refused to fund them. So they will have an appeal process, which the client will apply to, or will appeal against the decision. So what would normally happen in the first instance is the client will make an application to the insurance company, the case is sent on to their panel solicitors. Their panel solicitors say it doesn't have a reasonable prospect of success and tell the client that, and then the client can appeal. Carry on. So how do you ensure the second time round your client is successful at appeal? What we found is one of the most effective ways of doing that is to get a barrister's opinion on the case. Now, there are two ways this can be done. You can argue that you can give you can argue that you want the case referred for the FSO to refer it to one of their, not the FSO, sorry, the insurer to refer it to one of their barristers that they instruct, or you can instruct a barrister on behalf of your client and negotiate either on a pro bono basis or a no-win, no-fee, i.e. that if the case is taken on by the insurer, then the fee will be paid, something along those lines. Most of the time, the barristers we've instructed have agreed to provide the advice on condition that agree to provide the advice and then agree to be paid on condition the insured gets, the appeal is successful. And then we've actually managed to negotiate for the insurer to pay for the barrister's opinion. And it has really been quite effective using a barrister's opinion, because where the barrister says the case is likely to succeed, it's not likely that the insurer is going to be able to turn it down at appeal stage. You can also, failing that, go to the FSO and argue that you've applied, you've appealed, the insurer still won't take on the case, and so the FSO will look at it, and then the FSO will effectively force the insurer to get a barrister's opinion on the case. The problem with this is it's quite time consuming, and meanwhile the clock is ticking and your client's case is running. I don't need that. Right, okay. So how do you actually be the instructed solicitor in an insurance case? What the regulations say is that once proceedings have commenced, the client can pick who they like to represent them. So they can pick the law centre or they can pick the advice agency solicitor to undertake the case for them. Before proceedings commenced, it's a decision for the insurer, except in very exceptional circumstances. Our experience has been that because the clients are usually rejected at first instance when they apply to their insurance company, by the time they win on their appeal, this is specifically with employment cases, which you have to file the claim within 3 months, we've already had to file the claim anyway, so it's actually not been a problem for us. If you were doing something else like personal injury, it might be a different matter, but for employment purposes, it's never been an issue for us because we've usually already had to put the claim in. But what it's meant is that sometimes we've had to carry out some work on a pro bono basis in order to ensure that we actually get the client to stay with us, and also to get the to get to the point where we are where litigation has commenced.
I'm just going to skip over that because we've dealt with it.
Okay. I've already mentioned choice of solicitor and pre-litigation stage, so we don't really need to proceed on that. Okay, so what happens if the insurer won't fund the client's chosen solicitor? So they can negotiate with their provider, and the client can also complain to the FSO. There have been instances where insurers say, well, we want to fund someone else. So they try to find ways sometimes around the client not instructing one of their panel solicitors, like they'll have what are quite unreasonable terms for non-panel solicitors. Some of these include issues like having to have national coverage or having to have ridiculously high indemnity on insurance, being expected to work for a lower hourly rate than the panel solicitors, or working at a ridiculously low fixed fee. Overall, what the FSO has said in instances like that is if it deprives the client of choice and basically effectively makes the regulations that say they can choose ineffective, then they will usually always uphold the client's complaint and allow the client to choose their own solicitor. So there are a number of detailed complaints that we've included in the pack, but I'm not going to go over them now because we're going to run out of time if I start to discuss them. Okay, do I have to? I think I've done that. Yeah. Okay. Right then, so the client's decided that they want you to represent them, so what happens next? Okay, so you will usually get sent what are effectively the standards, that the insurer's standard terms of appointment. So this will usually just be a contract that sets out what you have to do, what your obligations are to the insurer. So effectively what it does is it creates a three-way relationship between you, the client, and the insurance company. So 2 matters you'll need to be aware of before you sign are, does the insurance cover you and what will you be paid? Obviously you need to know what the hourly rate is. So many insurers have clauses that limit the liability to the hourly rate they pay their panel solicitors. If it's less than that, you can complain. The FSO has effectively said that you should at least be paid the same rate as panel solicitors. The insurance policy is very unlikely to specify the hourly rate, so it's something that you would find out about later on down, or the client will find out about later on down the line. But what the FSO has said is if the hourly rate's so poor, it needs to be specified in the insurance policy before, so that the consumer has effectively has choice before taking it out. So unreasonable terms of appointment, I've already touched on this, but some of these are that insurance levels are too high, turnovers are expected to be over $1 million, query and qualifications, etc. And as I've already stated, most of the time these can be challenged. So you have a contract, it's a 3-way contract, so there are obligations to the insurer. So the terms of agreement will include notification requirements. Usually these are quite straightforward. They're things like if the respondents make a settlement offer, you're expected to notify the insurer. New evidence which might change merit, you would be expected to notify the insurer. And there would also be updates and stages upon which you would have to provide an update to the insurer. They're all pretty standard in any case, not particularly difficult to work around. Okay, you will also need to apply for disbursements. Okay, so many independent legal firms don't take on insurance work because of the rates that are paid are generally quite low, though law centres and not-for-profit providers are more likely to be able to carry out work at this rate. Generally, at the moment, the rates vary between about £100 and £150 an hour, depending on the insurer. It's usually between £100 and £150 an hour. Okay, so what's this about?
I think this is just the case that covers.
We've covered all this.
Don't need to go through.
Okay, one of the other problems that sometimes occurs is that you might not realise your client's got LEI insurance until you've already taken on the case. We had this with a client. We asked him, he said he didn't have it. Curiously, when it came to having to instruct counsel and realising that he might have to spend quite a bit of money on counsel, he suddenly found his LEI policy. But that basically created a late notification. So normally you have to notify within 180 days. And as I said, that's generally not a problem in employment proceedings unless you've already filed the claim and so on. But the FSO's position on this is that late notification in itself should not result in a rejection. So if that's the only reason why a claim is being rejected, then the insurance company should not reject it purely for the late notification only. They would have to also look at merits and so on. So this in itself wouldn't be sufficient for an insurance company to say, no, we're not going to fund this case now because you're now 1 month past the notification date or notification deadline.
I'm going to skip the next couple because it's just complaints which we've covered.
Okay, there are some other common issues that need to be addressed. So, if you're in the not-for-profit sector, you might not be used to keeping detailed schedules of cost. You have to do this from the beginning of the case. Even before the insurance company actually agree to funding you or signing the terms of agreement, it's still worth keeping a detailed schedule of costs because in certain instances, you may be able to back claim. So you also have to think about how you maximise on chargeable work. This is something, again, the not-for-profit sector is not so good at because you do your work based on what needs to be done rather than maximising on for-profit work. But obvious things would be like you make calls, you send emails, you record calls. You don't send an email that takes 2 hours to construct. You might send a series of emails. I know it sounds really manipulative, but unfortunately when it comes to the cost draftsman later on, having sent 10 emails will get you 1 hour's work, whereas having sent one long email if it takes an hour, you'll have difficulty justifying that to a cost draftsman. So the appropriate use of senior and junior staff in the case as well will be necessary. So when it comes to things that obviously like preparation of trial bundles and things like that, at a later stage you might be queried as why a senior solicitor has done that when it's something that a more junior member of staff could have done. File management and review. When you sign the three-way agreement, you will usually be told exactly how you're expected to manage the file. So you may be asked to have the client's case ring-binded and sectioned into specific areas, and generally that's what you'll need to do from the start. You also, SRA compliance is a given. Okay, so you've done the work, the case maybe has settled, or you've been to the employment tribunal, and now you have to submit the case to the insurer, again in the required format, which is why if the insurer says make the file A4 ring binder, put it in various sections, it's much easier to do that from the start. And you will generally be expected to then send that file back to the insurer together with the bill of costs. So then what happens is the insurer will then refer that to their cost draftsman, and then you will wait. After that, the cost draftsman will contact you and suggest that about 50% of the work that you've done isn't recoverable. And you have to then go through the process of arguing with the cost draftsman about what you should and shouldn't be paid for. We think there's potential where you might have a legal aid contract or something like that to negotiate that you can use a cost draftsman that you already instruct for legal aid purposes. We know that larger firms that take on LEI work will quite often have their own cost draftsman, and that doesn't seem to be a problem for lots of insurance providers. So there's potential there to use a different cost draftsman than the one specifically allocated by the insurance provider. Okay, so presuming you've battled with the cost draftsman and you've got most of your fees, that's pretty much a case from beginning to end. So what we're going to look at briefly now is the regulatory framework, the really boring bit. So there's the insurer's agreement, which is the terms of appointment. There's the legislation, and as I said, it's actually quite an unregulated area. There's the Legal Expenses Insurance Regulations 1990. There's case law, and there are the SRA rules, specifically Rule 4.1, and then the Financial Ombudsman Service decisions. Effectively, that is the regulatory framework for doing legal expenses insurance. Troubleshooting. Not going to cover this in much detail, but there are a few issues that you might encounter along the way, as we have ourselves, that can cause a few problems. Apart from obviously getting the insurers to fund the case in the first place, which can be quite time consuming because invariably you end up instructing counsel or providing a second opinion yourself, there's the issues with the schedule, with disputes around what you will be paid. Also there are disputes around the dates of retainer. So in certain instances the insurance company may try to suggest you should be paid for a shorter period of time. You may have to challenge them on that level, and there may also be delays in payment. I've had to complain in one of my cases, and I was about to take it to the FSO when the insurance company collapsed on me and agreed to make payment. This was because there was a delay in payment of almost a year. And that was because the cost draftsman kept changing and it just took a long time. And so I ended up complaining. And then I said, I'm not satisfied with your response, I'm going to the FSO. And then, curiously, the insurance company dealt with it very quickly after that. So sometimes you will have to make complaints. Though that all sounds really negative, and I'm not going to end on a negative note, because with some of our cases, we've actually managed to get insurance companies to fund us from before we signed the terms of appointment on the basis that we should have been funded from the date the client submitted their application for legal expenses cover. And we've also managed to negotiate higher hourly rates as well. So there's actually quite a lot of scope. It's not all negative. It's just there's quite a few barriers that you might have to jump over. But once you've actually got it, you can quite often negotiate. So it can be quite an effective way of basically creating a source of untied funding. Because if you get, say, £10,000 on an LEI case, if you do 3 cases a year, and you get £10,000 on each case, you're looking at quite a lot of untied funding. So once you actually take away what doing that case has cost you, you know, there's a potential there for that untied funding to be spent on exactly what you want it to be spent on. Because unlike with money from funders, you won't have to do specific things with it. It's actually profit for the centre. Okay. There's much more detail in the pack than I've been able to speak about today, but I just wanted to leave some time at the end. And I'm going to pass you on to my colleague Eddie.
Hi. That was excellent. Thank you. I mean, Elizabeth referred to the financial ombudsman on a number of occasions, but we found that it's the threat to go to the ombudsman. So don't get carried away that you have to go to the ombudsman all the time. And if you go to the financial ombudsman's website, there's a whole wad of relevant cases that we refer to when we're engaging with insurance companies. So every type of complaint that you may experience, someone else has already complained about it. And so that's where you seek that appropriate support in terms of your engagement with insurance companies. And I'd like to emphasise that most commonly the policies cover, as Elizabeth said, employment, consumer and personal injury. But I've seen policies that cover everything. You know, all tribunal and court work, and they're all different. So it's worth, in terms of your first contact with a client, it is worth engaging with them in terms of whether they have appropriate cover. Our ambitions are also wider than just doing individual casework. I mean, part of a project that we're involved in at the moment that's funded by the Legal Education Foundation is helping to raise capacity within the sector in terms of for people to take on this type of work. But we also see a role for key community stakeholders in developing provision of legal expenses insurance amongst their leaseholders, amongst their renters, amongst their members. When you think of it, local authority and a housing association have to buy huge blocks of insurance for the leaseholders, the renters. Similarly, membership organisations undergo the same type of thing. So we're looking to engage with key community stakeholders. So as part of their purchasing power, to impress that they use their purchasing power to purchase, as part of their block contracts, legal expenses insurance at no cost. Otherwise, they go elsewhere. And if they do that, then they're serving a community purpose in terms of access to justice simply by being very choosy in terms of what policy they take on.